My name is Thomas Burrell. I am the president of the Black Farmers and Agriculturalists Association Incorporated. This will be a short video explaining to some degree an order that has been issued by a federal district judge in the District of Columbia named the Honorable Reggie B. Walton. Judge Walton is one of the federal judges that has jurisdiction over two of the civil rights lawsuits that have been filed against a defendant, the United States Department of Agriculture. Most of us are familiar with these lawsuits. There was Pigford 1, and then there was Henry Black Farmers litigation, Pigford 2. There was a third lawsuit styled Maryland Keepsigle versus Tom Vilsack, Secretary of Agriculture. The fourth lawsuit was a lawsuit filed by a group of Hispanics Americans, and it is referred to as the Hispanic lawsuits, which is basically Guadalupe Garcia versus Tom Vilsack. A fifth lawsuit is styled Rosemary Love versus Tom Vilsack. Now, the two latter lawsuits were combined into a voluntary claims process, and now those lawsuits or voluntary claims processes are referred to as the Hispanic and Female Farmers and Ranchers claims process, or claims resolution process, as it were. You may recall that in some of the meetings that we have conducted around the country, I made reference to, I used an analogy. I said that if you were suing me or if I were suing someone else, we would literally or file a claim in a state court and or a federal court. But when you're suing the federal government, Congress has to approve the lawsuit. There's an old saying that says the king can do no wrong. Well, when black farmers filed their claim in August of 1997, or their complaint rather, against the defendant at that time was then the Secretary of Agriculture, a person by the name of Dan Glickman. A group of black farmers went into the federal courts in Washington, D.C., and that claim or that lawsuit is styled Timothy C. Pigford and others versus Dan Glickman, Secretary, United States Department of Agriculture. Congress, though, in order for those farmers to prevail, had to authorize or do what is referred to an act of Congress. Congress indeed acted. And on October the 28th of 1998, Congress passed, and the then sitting president, Bill Clinton, signed into law a statute, or a, shall we say, the tolling of the statute of limitation that allowed these farmers to proceed with their case. And it went from about 8 individuals to 400 individuals, and now there are thousands and hundreds of thousands of individuals who have been claimants and or parties to these lawsuits since August of 1998. Or I'm sorry, at least August of 1997. Again, on October 28th of 1998, Congress indeed acted. And they signed into law, among other things, a provision that allowed the claimants, or all potential claimants in this lawsuit, to waive the statute of limitations. So, in other words, this lawsuit has been open since October the 28th of 1998. And what that waiver meant was that individuals could go back beyond the regular, what is called 2 years, and file claims against the defendant. In other words, every lawsuit, for the most part, with the exception of some rare ones we won't even get into, will have a statute of limitations, even going all the way back to the Old Testament. That is to say, if A has been wronged by B, A has a certain amount of time to take B to court. And if A waits until that time is up, the court will not entertain A's complaint. A will have come into court too late, beyond the statute of limitations. The law that USDA, or the, shall we say, provision that USDA violated against all of these farmers and ranchers is another statute known as the Equal Credit Opportunity Act. And the Equal Credit Opportunity Act is an act that says any creditor who discriminates against any claimant during any phase of a process will have violated that act, and therefore that person can sue them. The Equal Credit Opportunity Act had a 2-year statute of limitation. Therefore, when those farmers filed their lawsuit in August of 1997 against USDA for violating the Equal Credit Opportunity Act, the court then says, well, you guys can only go back 2 years. Therefore, if you file the lawsuit in August, basically, of 1997, you can only go back to August of 1995. Well, most of the claims, most of the arguments, and most of the wrong had been already done. So the court says in order for us, the courts, to hear arguments that happened prior to August of 1995, then Congress has to toll the statute of limitations. And when Congress passed the act then, on October the 28th of 1998, they said, we're going to roll the clock back. We're going to roll the statute back to January the 1st of 1981. That's why when you're answering those 4 questions, the court wants to know first, are you filing a claim on behalf of a person who was at least alive on January the 1st of 1981? Because that's how far they roll the statute back. Now, that's called tolling. When you stop something, when you go to a toll booth, you have to stop. So therefore, when Congress tolled the statute of limitation, they said, Your Honor, we want to stop it. We want to make sure that people can roll their claims back all the way to 1981. As we said, there's this phrase going around, terminating the tolling of the statute of limitations. Now, what USDA is asking the courts to do is to, in effect, terminate the tolling, meaning the sun has been shining on these lawsuits. Remember, and I have given an example, a biblical example, regarding an event that happened thousands of years ago with a person who was leading the children of Israel by the name of Joshua. And Joshua was battling with his enemies, or their enemies, and God stayed the sun. The sun had a 24-hour rotation. It comes up at a certain time, and it goes down at a certain time. So what God did for them to give them some extra daylight, he stopped the sun. He told the sun. And therefore the sun remained shining to allow Joshua and all the other children of Israel and the men of war to finish their business before dark. Well, in effect, when Congress passed in October of 1998, the tolling of the statute of limitation, it in effect said, wait a minute, we're not going to let the sun go down on this lawsuit. This lawsuit will be open until such time that someone file a motion to terminate. A motion then to terminate the tolling means let the clock start again. Let the sun go down. And that's what USDA is asking the court to do. And at least the first judge at the district level federal district court level, Judge Reggie B. Walton has signed an order letting the defendant know, or letting everybody else know, that, hey, this lawsuit is going to come to a close. We're going to let the sun go down on this lawsuit. Therefore, the way you let the sun go down on the lawsuit, since it was told, is to, quote unquote, terminate the tolling of the statute of limitation. So what we say is what? Terminating the tolling of the statute of limitations. Now, the question that everyone is asking is, what does this mean regarding me or my claim? If I have a claim, if I want to file a claim, did I have a claim, etc., etc., etc. What the defendant is asking the court to do is to, as we said, what? Terminate the tolling of the statute of limitation. Let me give you a couple of everyday examples. I have a bank account at ABC Bank. And ABC Bank closes on Fridays at 5 o'clock. And I've got my payroll check. I need to go take it to the bank. And I get to the bank at 4:55. I make it to the bank 5 minutes before the bank closes. And when I get inside of the bank, there's a long line of other individuals who want to cash their checks as well. So at 5 o'clock, what you will probably see is someone coming from behind the counter, going to the door and locking the door. What they are doing is they're not making the people who are in line leave the bank. They're making sure that people outside who have not made it into the bank, they're not letting them in. Okay? That is to say, the people who are already in will have time to finish their business. Whether the bank will have to stay open 5 minutes after 5, 5:30, or 6 o'clock. But no one can come into the bank, but they're not necessarily putting anyone out of the bank. What we're simply saying is, Tom Vilsack, the Secretary of Agriculture, is asking Judge Walton to lock the door to the bank vault, to lock the door, to make sure that people who may have not filed a claim, or people for whatever reason who have not made up their minds what they want to do, the door will be locked. And the date that this door is going to be locked is June the 8th of 2015. Judge Walton has signed the order. He signed that order approximately April the 23rd. And individuals who represent farmers and all of their claims and their attorneys will have 30 days from April the 23rd, which is May the 22nd, basically, to file a motion to object. If we were in a football game, let's say that Judge Walton has made a call. He's a referee, and you don't like that call, you throw down a flag. Rest assuredly, this association and even the lawyers who are representing the other members of these lawsuits, particularly members of the Hispanic group and women farmers, have also filed objections. But it doesn't stop the fact now that as of now, what we call drop dead date is June the 8th. We're calling our members. We're sending out letters to our members to say that June the 8th, you must be in good standing. If you're not in good standing by June the 8th, there's effectively nothing that we can do for our members. I'm going to go back to that bank example in a minute. Let's say that there are 3 people coming to this office, the Black Farmers and Agriculturalists Association, and they arrive on June the 10th. Let's say that there's a person by the name of John Doe. John has his brother with him by the name of Billy Doe, and John also has with him his sister named Susie Doe. Now, John Doe is a member in good standing with this association. As a matter of fact, his membership dues are due on June the 10th, 2 days after the drop dead date. John then is in good standing on June the 10th because his membership didn't lapse, as it were, until 2 days. But his brother Billy, though, had a claim, and Billy's dues were due in February. And Billy, for whatever reason, did not renew or his standing with this association. Can Billy Doe then, on June the 10th, become in good standing? For all intents and purposes, no. He's 2 days late. Let's go to Susie Doe, their sister. Susie says, I want to become a member. I heard my brothers, Billy and John, talking about this lawsuit, and for whatever reason, I decided not to be a member, or I decided not to be a claimant, but I want to do it today, and I'm riding down here with my two brothers. Can Susie Doe become a member on June the 10th? She can, for other benefits that we are offering. But since June the 8th was the drop dead date, we cannot. We will have to let Susie know, even if you become a member of this association, it will not help you. It will not be for the benefit of any of these 5 lawsuits, because the tolling of the statute of limitation was terminated 2 days ago. Let me give you one more example about how this termination or terminating of the tolling of the statute of limitation works. Let's say here again, I'm going to my favorite restaurant, and my favorite restaurant closes at 10 o'clock p.m. And I get to the restaurant at 2 minutes before 10, 9:58. And I'm going to order me a big juicy T-bone steak, and I want them to cook it really, really slow, and it normally takes about 20 minutes to cook my steak. They know me, okay? Now, if I made it to the restaurant 2 minutes before they closed, I can still get in and order my steak, order anything else from the menu. However, if someone walks behind me at 10 o'clock when the restaurant is effectively closed, they can't get in. That is to say, here again, what Mr. Vilsack is asking is the courts to do what? Lock the bank door, to lock the restaurant door. He's not asking the court to throw anybody out of the bank. He's not asking the court to throw anybody out of the restaurant. He's asking the court not to let anybody else into the bank, not to let anybody else into the restaurant, not to let anybody else who might otherwise have a meritorious claim of discrimination, not to let them in. And that the only people who will be able to finish up, order their steaks, order checks, to make other deposits, they can still do that if they have standing on that day, which is the drop dead date, June the 8th. Because we're getting a lot of calls, people are saying, well, does that mean we're going to get put out of the lawsuit on June 8th? No. I think both of those examples, the bank examples and the restaurant examples, are sufficient enough to know now basically what the defendant is asking. We have known that this was going to be the case. We've known all along. Every lawsuit has a beginning date and it will have an ending date. We, our lawyers rather, like the lawyers representing some of the other parties, we're going to object to this termination of the tolling of the statute of limitation. And our attorneys believe there is sufficient case law to have the court to deny Mr. Vilsack his motion. But since we don't want to tell people, don't worry, wait until after the June the 8th, because if they don't prevail at the appeals level and or at the Supreme Court level, then Judge Walton's ruling will be final and forever, as it were. So we're contacting all of our members and asking them not to procrastinate, because maybe that might be why some people are not. Well, we know that, like anything else, people are going to wait until the last minute. Now, I'm going to repeat myself again for the sake, or out of the abundance of precaution, rather. Vilsack, the Secretary of Agriculture, has filed a motion, and Judge Reggie Walton has granted him his motion, terminating the tolling of the statute of limitation. Let the sun go down on these lawsuits, lock the door to the bank vault, and lock the door to the restaurant. However, if you are, and the reason we're asking our members to make sure that they're in good standing, one of the defenses that we have against Mr. Vilsack is that we have some other pending motions that are unresolved, and that the court should not grant him his, shall we say, petition to lock the door effectively because there are still some pending motions. However, those pending motions may not benefit, as it were, people who are not inside of the restaurant, who are not inside of the bank. So we're simply saying if you're on the outside looking in, that's probably where you will be with respect to these lawsuits. It is just that important. So we're calling all of our members. We're sending out emails to all of our members. We're mailing letters to all of our members. And we're going to send out an email blast and post this, shall we say, video on our website conspicuously to make sure that our members can go to these websites, go to our website rather, which is www.mymybfaa.us. Or you can call the office at 901-522-8880. I'm going to come back with a couple of more closing arguments, and that should do this video. Thank you. I want to reemphasize and reiterate a issue or a question that is being asked that I referenced in my example with John Doe, his brother Billy Doe, and his sister Susie Doe. Remember, John Doe was in good standing as of June the 8th, cutoff date. He was already inside of the restaurant. John was inside of the bank. Billy, his brother, was in effect in the bank, but his standing, he lost his standing as at least it relates to this association, as it relates to this association. Most of our members are only parties to the lawsuit because of the motions that we have filed. Now, you may have been a party or received standing through some other method. So when I talk about Billy Doe, I'm assuming that Billy was never on the list, never on the judge's docket, but he was a member of the Black Farmers and Agriculturalists Association, asking us to intervene for him, asking us to file motions on his behalf. He was at one time in good standing, but he lost his good standing. He had, as a matter of fact, I think in our example, his standing expired in February of 2015. So he had until June the 8th, as it were, to renew his standing. But when he came in on June the 10th, there's nothing we can do for him. He was 2 days late. Had he, say, visited the office 2 days earlier, June the 6th, and renewed, then he would have reestablished his standing, at least with this association. But the question that a lot of people are asking is, and in my example, it deals with the sister, Susie Doe. Susie was never a member. People are calling, asking the question, is it too late? I've never been a member. Is it too late? Well, the question is, are you in the restaurant already? They're not going to lock the door to the bank until when? June the 8th. They're not going to lock the door to the bank or the restaurant again until when? June the 8th. Therefore, if the sister Susie had come in earlier on June the 6th, then she would have been in time. She would have been inside of the bank when the door was locked. She would have been inside of the restaurant when the door got locked. But when she showed up 2 days late, it was too late. The door was already what? Closed. Therefore, for those individuals who are non-members and who are calling and says, well, is it too late? No, it won't be too late until midnight of what? 2008. So I just want to clear that up for non-members, because all of the motions that we have filed in court to intervene, Rule 24s, etc., and other motions to include the one to, in effect, deny the defendant, Mr. Vilsack, his current motion for the termination of the tolling of the statute of limitation, are for the benefit of people who have established standing. You heard me use that word in time past. Get used to it. Standing means what right do you have to make an argument before a judge. Standing, let me say it again, S-T-A-N-D-I-N-G, just like it sounds. What right do you have to stand before one of these judges, these federal judges, to make a meritorious claim of discrimination? Well, Judge Walton has said you have until June the 8th. Now, as I said, most of the attorneys representing even the Native Americans, the Hispanic American component and the female farmers and ranchers component, and our lawyers are filing motions asking the appeals court to deny Judge Walton's order or to reverse his order, because there are some other issues for people who are already in the restaurant, as it were, already in the bank, to make sure that those individuals who are already in will have a time to finish up their paperwork, to make their deposits, to order their steaks, to, in case the steak is, you ordered well and it's medium, you just send it back. You got in the restaurant, in time. So therefore, whatever business that you need to finish up, and I'm talking about affidavits, whatever business, whatever documents that you will need to finish up, we're making sure that you will have that opportunity, and we will definitely keep you posted as to the particulars regarding this latest motion or order to terminate the tolling of the statute of limitations. Thank you.